What's up, YouTube? What it do? Man, my inside man just keep dropping these joints on me. I guess I complained yesterday about the docket number. They said we gonna help E out. Dude was mad. He was cuffing the docket number, bro. You share information. That's how I know some of these jokes just petty. Then my girl was like, "What's wrong with you? Ain't nobody gonna do nothing for you. They ain't gonna give you nothing." Somebody gave me something today though. So I got another one that's interested. This worth reading, man. Come on round. What up? What up? What up? But my man, no face, no case. Tap in. Let me plug my iPad up while I do this, y'all. Y'all know we about to get into. We about to get into some more of that. What's going on? The Puritan boys. Puritan Ave boys. They just want to be first. Laugh out loud. We call that nut holding. Yeah, but what's the purpose of being first when we all trying to get to the bottom of it and you don't even know what you're reading? Meech is scared for his life. Trust me, the other side was vicious, and Meech knows he needs to be in witness protection like Tammy. If she still is or was, what y'all think? Meech is scared for his life? I'm looking at the bigger picture. I don't know if he's scared for his life. He out in public like Rayful was. Yo, my man, Big Joe, when you lose so much weight, big homie. Bro, you sitting there talking to me about when did I lose so much weight like you knew me from yesterday. Weird. Anyway, as soon as we get a few more people in here, I'm gonna show y'all something that I saw was funny. I probably ain't mentioned it until I seen it mentioned in a court document. I knew you from day before yesterday. Alright. You might need to go to witness protection. Oh, somebody got you out of there already. And what does your beanie say? Strength and solidarity. That's the credo. His body language was worried, concerned. Yeah, but I don't think it was for his life. I think it was for his reputation, which may ultimately mean his life, though. But wait till I read this other transcript over here from this motion, man. And watch my body language and my eye contact with the screen because I ain't reading all of it. I think it's going to be something wild in the bottom of this jump. We about to turn up on that jump as soon as we hit 100. As soon as we hit 100, we going to go straight into it. And this coming out of Cuffy docket sheet. His body language was worried. Hey, Go TV, I appreciate the love too, bro. All the time, even when I don't say it. Remember that, man. Let the iPad charger just a teeny bit. Shout out to Brownsville. Good work out here, bro. Salute. What's your NCAA college team, Eon? Ohio State. Beloved, ain't no way the Meech and Suarez shouldn't have been part of Cuffy's indictment. Yeah, we gonna read another piece of that. I don't know if you tuned in, but if you didn't tune into the last live, go look at the last live where I read Suarez's complaint. Suarez got an order of acquittal. I guess, man, he's shaking bacon on their ass. Meech whole vibe is like he stepped in a pile of crap. Yeah, I'ma subscribe. Okay, partner. Come on, I think we're gonna dig into some of that junk real quick before I even get ready. There we go. Not bad. I just got some information on that clown, that Team Malpo dude. Detroit said they ain't rocking with you. But anyway, let's get back to this business right here. Like, what kind of attorney Suarez got? You dig? I don't know, but check this out right here. Where is that? It's over here. All right, here we go. I'm coming from docket 544, United States of America, Eastern District of Missouri, Eastern Division. This is Dionnie Gatling joint. Transcript of motion hearing before the Honorable Shirley P. Mansa, United States Magistrate Judge, October 25th, 2017. Y'all with me? Oh, we at 110. I lived up to my word. 14 with Chapin Street checking in. Shout out to 1-4. Suarez got you back in your groove again. Yeah, we about to rock out. Here we go right here. The following proceedings were held in open court on October 25th, 2017. So this is not like what you read, not what you read, what we read together about Tammy in regard to closed court. This is an open court hearing. The court, we're on record. You can stay seated. I don't think we need Mr. Gatling. We're on record in the United States versus Dionnie Gatling, the case number such and such. We're here on Mr. Gatling's motion to reconsider detention. Counsel, please announce your presence to the record. So this is Mr. Hoag, or however you say it, H-O-A-G. I ain't sure how you pronounce that. That's the attorney, Dean Hoag, for the government. So that was the government attorney that was questioning Tammy on the other joint, and Mr. Trogg, Joanne Trogg for Mr. Gatling, who is present and seated at counsel table, Your Honor. The court, good morning, all right. So we're here on a motion filed by Ms. Trogg on behalf of Mr. Gatling for reconsideration of detention. Brick Squad, what's up? This after Cuffy's Frank Hearn chat. All right, okay. Mr. Trogg, Ms. Trogg, I understand that Mr. Gatling has raised two grounds for pretrial release, the first being under the Bail Reform Act. And the position, as I understand it, is new facts that have come to light since my initial detention order, including facts related to Mr. Gatling's health and facts related to evidence disclosed by the government, and some of which presented at the Franks hearing in this case are material to the factors that I have that I would apply under the Bail Reform Act. Ms. Trogg, that is correct, Your Honor, the court. And the other is a due process challenge. Is that correct, Ms. Trogg? That is correct, Your Honor, the courts. Okay. So what I'd like to do this morning, and I have read the submissions from both parties, and I have a good understanding, I think, of what your respective positions are, but I do want you to address this morning the specific facts that you think under the Bail Reform Act would justify pretrial release. What are they? Why they are new and why they warrant a release. And then on due process based on reading of the parties' written submission, and Mr. Hogg has heard this spiel before because Mr. Rush raised a similar argument. First, there doesn't appear to be any dispute that the fact is that in this case, like United States versus Briggs and United States versus Hare, which are cited in my September 14, 2017 order, I think that might have been in relation to Mr. Rush's motion, but those factors, I believe, govern the due process issue. For y'all that's not up to speed, Mr. Rush is a co-defendant of Cuff. And I just want to, excuse me, and I just want to make sure, so we're all on the same page, the factors that I believe need to be considered in evaluating due process challenges are, 1, the non-speculative length of the confinement and expected confinement, the extent to which the government bears responsibility for delay, the gravity of the charges, and the strength of the evidence justifying detention. And that would include the existence of any rebuttal presumption for detention. My reading of the case is that although no one factor is dispositive, the way that the case seems to apply those factors is the longer the length of detention, the more weighty and other concerns have to be. And where pretrial detention is very long, and some courts have put that into the 2 years and more, then continued detention is justified only if the government is not responsible for any significant portion of the delay, and special circumstances indicate that the defendant's relief will pose an extraordinary threat to the government's regulatory interest in pretrial detention. And I'm saying all of this and outlining these factors to make sure that we're all on the same page. And I found no Eighth Circuit cases that require a different standard than what I've outlined for the parties. And so the first thing I want you to do with respect to the due process part of the argument is to alert me if either side is aware of any Eighth Circuit cases that would require me to apply a different standard than what I believe the standard to be based on my reading of the case law. So the judge in this case right here wants to see if there's any precedents to go for or against what he want to rule on for the detention of Cuffy, and they filing these motions, and he giving them an opportunity to orally address these motions. The second thing I want you to do for me with respect to the due process challenge is to discuss the presence or the absence of these factors, assuming these are the right factors under the facts of this case with respect to Mr. Gatling. So that's why I wanted to have the hearing. And if there are other issues, arguments that you believe are pertinent to either of these bases raised by Mr. Gatling, certainly I'm happy to hear them. So, Ms. Trogg, that's Cuffy attorney. If I may, Your Honor, the courts, yes. All right, let's see what they're getting into right here. Like I told you, I ain't proofread this first, so whatever it is, it is. So, Mr. Trogg, first, I would certainly concur with your assessment that there are no Eighth Circuit cases which specifically address the situation that is before the court right now. I think counsel is relying on cases from other circuits, the District of Columbia. And we certainly do not disagree with the assessment of the three factors under the Briggs that must be addressed. It is our position. Oh, excuse me, Your Honor. So we believe that the court has correctly, Your Honor, has correctly assessed the three criteria regarding Mr. Gatling's confinement concerning his length of confinement, the government's responsibility to the delay, and the strength of the strength of the evidence justifying continued detention. To put this case in perspective, Your Honor, Mr. Gatling has been in custody since March of 2014. That is 43 months. 43 months of deprivation of his liberty that pretrial detention entails. In all of our searching, Your Honor, as well as looking in the Ali case and the Briggs case, the longest length of time that we could find in detention in the amount of 33 months. We have now exceeded 33 months by 10 months. And quite frankly, we do not know when the trial of this case will be had. It might be in 2018, but we have no guarantee. As the court's aware, we had 9 days of Frank's hearing, and it encompassed a tremendous volume of testimony. They had 9 days of that Frank's hearing. We only go over about 1 day of that. Well, I got the 271 page on, but anyway, so we believe that one of the first prongs that must be looked at is simply the length of time that Mr. Gatling has already been confined, and down the road, how much longer he may be confined. The second prong, Your Honor, is the government's responsibility for the delay. Now, I'm not accusing the United States Attorney for the Eastern District of the delay, but I think we can all agree that there was significant delay in the government's providing discovery regarding the ongoing investigation with regards to Agents Cromer, Swoop, Aguilar, and various and myriad of other people who were subpoenaed to testify under oath in both the OIG and the OPR investigations. Ms. Trog, oh my gosh, I'm sorry, Your Honor, I'm so sorry. Her phone rang in court. That's okay. Ms. Trog, the government knew in the spring of 2015 that they had a problem. And they went through an enormous amount of, as I said, depositions, sworn testimony, but we only got it in dibs and drabs. And this just added to it. If we recall back in the spring of 2016, we were trying to figure out dates for the Franks hearing. Well, every date we chose had to be set back because there was receipts of additional testimony, additional discovery. Even, Your Honor, you'll recall during the 9 days of the Franks hearing, there was significant discovery that the government here received, and that in a couple instances, we were just provided the morning before the hearing. So I do believe that the government bears some responsibility. And I'm thinking the government as a whole, Your Honor, the government bears a fair amount of responsibility for the delay. Now, the third prong is perhaps the most important prong, Your Honor, and that is the strength of the evidence justifying the detention. In Briggs, the court recognized that the longer the detention, the longer the prosecution part in prolonging it, the stronger the evidence justifying the detention must be. So the longer that Mr. Gatling is in custody, the more compelling the evidence must be. And that I will submit to you, Your Honor, with was disclosed, or their lack of evidence in the confines of the 9 days of the Franks hearing. The government's case, we believe, Your Honor, is predicated on the Title III affidavit. I said that yesterday on Dogface TV, which of course was the subject of the Franks hearing. The cornerstone of that affidavit was CS1. CS1 is Tammy, we all know that. And Tammy testified, Your Honor, with regards to the various matters, some of which were in open court, and some of which were at a sidebar. Sidebar meaning at an open court. They might have had the white noise on, the hushers, but you can't hear it in the gallery. The people in the courtroom were not privy to that. Tammy, hold on, but I think to be general, Your Honor, that the credibility of CS1, which is Tammy, or her lack of credibility became very paramount in the defendant's case. Tammy is actually the defendant's biggest asset. CS1, which is Tammy, in our opinion, Your Honor, destroyed the affidavit. Now, remember me and Dogface was talking yesterday. I said, yo, it's one affidavit and it's another affidavit, and we had a discussion about what is an affidavit. And I said, yo, for some reason, I had a feeling like she tried to destroy the case after the DEA agents wouldn't return her call. The judge, she couldn't get online. The clerk instructed her to call the U.S. attorney, and then one thing led to another, and she said whatever she said. But I'm going to read that again. I think to be in general, CS1 is actually the defendant's biggest asset. The defendant, Tammy, in our opinion, Your Honor, destroyed the affidavit. She destroyed the affidavit because of her own credibility, again, or her lack of credibility. She admitted to lying. Should have been done. She admitted that she would lie at the direction of the government agent. She admitted that Agent Cromer would feed her information so she could pass it on to other agents. She lied with regard to a three-way phone call that took place on August 5th that never took place. Y'all following me, bro? She lied about an August 5th phone call that never took place, and they got that just in emotion. She lied that Cromer was in her residence, and that simply was not true. That was borne out by, maybe it's a misprint, that was brought out by the testimony of Agent Cromer, who testified that he was in South Carolina with his family, as I said yesterday. She lied a lot. She lied that she lied. She said, well, although this wasn't so much a lie as an omission. I knew I was getting paid, but I didn't know why I was getting paid. And it seemed not to bother her, the court. I was going to ask you a question, but I'll let you finish. Ms. Traub, okay. She also admitted very candidly that the allegations in the affidavit were in fact lies, and she recanted them. The allegations in the affidavit were lies, and she recanted them. Do you know what that means, y'all? That means she took them back. It's almost like a witness testifying against you and then taking it back later. She recanted them. She also prepared her own affidavit. Whoa, so Dogface was right about her preparing the affidavit. She also prepared her own affidavit at one point where she recanted many of the allegations that were contained in the affidavit. She also admitted that she and Agent Cromer were in an illicit sexual relationship. This was born out of out by Agent Cromer's testimony that he was involved in an illicit relationship with her. She admitted that she had no prior dealings with drug dealers, drug personnel, yet this was a woman who provided monthly stipends or provided money on various inmates' commissary funds. Y'all follow that part? They said Tammy admitted that she had no prior dealings with drug dealers, drug personnel, yet Tammy provided monthly stipends or provided money on various inmates' commissary funds monthly. She portrayed herself as an innocent individual, that she was just doing what other people were doing, told her to do. And the reason that her credibility becomes so important, Your Honor, especially with regards to Mr. Gatling, which is Cuffy, is with regards to this area of threats, which is set forth in the government's response. She makes allegations about her safety. She makes allegations that she feared for her life. She made all kinds of allegations, Your Honor, but when you look at the 360 degrees of her, what do we have? We have a woman who says she was afraid, but she had no hesitation going to the Bureau of Prisons facility to visit Mr. Flenory. She had no hesitation, Your Honor, to lie. She had no hesitation to establish one fact. She was the most important person there was, and nobody else made any difference. She lied in her bankruptcy. She didn't even report her income. And the one thing I gather from her testimony, Your Honor, is that it's everybody else's fault. If I'm in this position, it's everybody else's fault. It's Gatling's fault. It might be Mr. Flenory's fault. Everyone except Tammy. Now, specifically, she talked about some threats that she believed that she received from the daughter of Cuffy, Tamara. And I'm referring to a threat on March 16, 2015. As it is noted in both our motions, the government's response, Margaret Henderson, is not an associate of Mr. Gatling, which is Cuffy, but rather Margaret Henderson is the mother of Tamara Gatling. And Margaret Henderson is in no way, shape, or form connected with this matter, except her phone was used by her daughter. Now, one of the difficulties that was raised earlier on, remember in the spring of 2015, her name came out inadvertently. And she talks about a phone. Mr. Hall, should I be objecting if I feel like the facts are wrong, or should we just not? I don't know what you want me to do, okay, Your Honor, because I don't want to lengthen this process, but I'll just sit down. The court. I guess, Mr. Hall, what I would like for you to do is, if there's a factual dispute, I want you to point it out in your response to anything that Miss Charles says. You're not taking those kind of notes. I'm not taking those kind of notes, Judge. The court. But if there are big picture things you want to highlight, just highlight them in your response. That way she can, and Ms. Trog, you did start to tie this back into the justification for detention. But I want us to keep focused on that, okay? Just assume for the moment, for the purpose of this hearing, that because these are issues that clearly I'm going to have to decide in connection with the Franks issues, which are now submitted to me. Assume for the moment that I agree with the defendants. Whatever position, what your position is going to be, tell me how those facts are relevant to the factor on justification for continued detention. Because you are going to have to tie that back to the initial reason for detention, okay? The initial reasons for detention, and I think you're starting to get there when you're talking about threats. That's clearly a big issue. I'll be perfectly candid with the parties. That's a big issue, particularly with respect to Mr. Gatling, because the government has raised that as an extraordinary reason that justifies his continued detention under the due process analysis. So I want you to focus on that. And let's not lose sight of the fact that there was a detention hearing, that were factors that were presented to the court, and I made a decision based on those factors. So you've got to tell me, how do these new facts, the things that came to light in the Franks hearing, how do they impact the original decision? Ms. Traub, understood, Your Honor. The court, one way or the other. Ms. Traub, understood, Your Honor. What I was finally getting to, perhaps too long of a prologue, was there are two issues. One is whether the defendant represents a danger to the community and whether there is a risk of flight by the defendant. Those are the two basic matters, I believe, which this court must decide. Certainly under the Bail Reform Act, under due process, okay? And so the ultimate burden falls on the government to present clear and convincing evidence that the defendant represents a danger to the community. Clear or convincing evidence, not preponderance. Preponderance of the evidence governs the issue of the risk of the flight, but rather the focus should be, I believe, Your Honor, on this clear and convincing evidence. And so when the issues of the threats are raised by Tammy, one, she talks about a phone conversation, but nobody heard the phone conversation. We just have her recitation of it. She talks about someone in Atlanta following her in a black Nissan Maxima vehicle, but there's no ties. She never saw it, so him before, she had no other contact. There was no other difficulties with this. And, Your Honor, we would posit that there is no clear and convincing evidence other than the statements by Tammy, which we believe her credibility was destroyed during the Franks hearing. The courts, okay, Ms. Traub, and the difficulty and the tenor of her conversation was what suited her at the time. So we believe, one, that there is no clear and convincing evidence that while this court might have thought, and as this court said in the earlier on its order of 2016, short of the full-blown Franks hearing, the undersigned cannot say whether the allegation misconduct, the alleged misconduct of the DA agent involved in the investigation of this case is material, otherwise has any bearing on the issue whether there are conditions of release that will reasonably assure Gatling's appearance and the safety of the community by a person in the community. We believe that the evidence elicited does not raise to the level, never has risen to the level that Mr. Gatling poses a danger to the community in general or to CS1, which is Tammy. Tammy isn't going to be called as a witness. The government has admitted that. They are not going to call her. So why in heavens would we want to do anything with Tammy, CS1? Because we never did anything with initially, and we're certainly not going to do anything with regards to her Now, Your Honor, with regards to the other issue, the risk of flight, Your Honor, we believe that we set forth sufficient prophylatic measures in both of the motions in 2016, and we were retained again. And I'm certainly not going to go through in paragraph to paragraph here, Your Honor. But if Mr. Gatling is placed on home detention, the government can certainly impose enough prophylactic measures where he will know exactly what he's doing, where they will know exactly what he's doing and when he's doing it. I've had too many clients, a couple now, who are in home incarceration, and the lady walked 500 feet out of there was a phone call, and why had she went too far out on the sidewalk? So I believe that there are significant measures that the government can take to assure Mr. Gatling's appearance at any and all court proceedings. His wife, we would even recommend that she be appointed a third-party custodian. So, Your Honor, believe, that's the fact, John. First of all, I'm going to get into the dispute with respect to the Franks hearing and the credibility of the witnesses, whatever else it is. That's already been argued in a memorandum, and it is what it is. What I'm going to talk about is you are talking about due process and if that's a violation. What expectations of the length of the incarceration, which is the government does agree, is a significant amount of, but the factors that we're talking about on the seriousness of the charges, nothing can be more serious than the elimination of two witnesses, Mr. Morgan, and back in 2010, I can't remember his name right now, but he was murdered outside of a clinic, and there's credible evidence. There's credible evidence that a grand jury would find probable cause to believe that Mr. Gatling, was involved in both of those. And nothing could be more critical or serious in a charge that really parlays into what CS1 Tammy had to go through. She talks about lies. I'm not going to argue about lies. What I'm going to say is none of the information that we're talking about here, none of it, was out there before she was outed in March of 2015 by defense counsel for Mr. Gatling. Not inadvertently, but deliberately. He outed her. And all of her actions with respect to that have to do with protecting herself and protecting her daughter. And it wasn't just a single act of intimidation. She was called on the phone. She was followed at her house. She was followed at her office. She was threatened by his family. He actually even got on social media and dedicated during the Franks hearing. And dictated during the Franks hearing. And while she was on the stand, she received a message from somebody related to the Gatling case. It is clearly it is a case of continued intimidation that ties into whether or not he should be released. He orchestrated these things from prison. While he's sitting in prison, he has people, that were willing and able, to intimidate her, to an attempt to intimidate her so that she would not testify at the Franks hearing. The factor says the extent of which the prosecution bears responsibility for the delay, and by the prosecution, I'm talking about us, not the government, because some of those things were out of our hands. That is the prosecution's hands. She wants to lump us into the government, but OIG and OPR conducted their own investigations. We would have been remiss had we not provided them with the extent to which the witnesses were cross-examined, disposed. There were over 30 depositions from the OPR, and I don't know how many from the OIG. And certainly there were delays in getting that. But they wanted them. They asked for them, and in terms of delay with the witnesses during the Franks hearing, those were their witnesses. If you recall, Agent Cromer testified, his lawyer said he was going to take the fifth. And remember, he didn't take the fifth. And he answered questions. And then everybody, surprised, said, well, we need to bring him back. And not only did we bring him back once, we brought him back again. All agreeable with the defense because they wanted to hear from Mr. Cromer, the court. Well, and I kind of raised this in the last hearing, Mr. Hall. It seems, I don't know. Don't you think it seems a little Byzantine to hold it against the defendants that they took advantage of disclosures that they were entitled to? They were entitled to that information. So, Mr. Hogg, I'm not faulting them. I'm explaining the courts. But I'm going to have to put it in somebody's column, right? Who caused the delay as to the government's versus Mr. Hogan. Who is the witness? The defendant. Who is the witnesses? Whose witnesses was it? The court. Well, I don't know. Mr. Hall. Did I call them? Did we call them? No, the defense called them. Ergo, I don't know how we could be blamed for a delay in calling a witness when it's their witness. Had it been my witness and we had these delays, well, then maybe you put that in my column. Maybe you do. Maybe you don't. But the long and the short of it is their witness, not my witness. And the strength of the evidence, well, as far as we're concerned, okay, with respect to the charges that we're talking about, the evidence has not been touched. There are 2 separate incidents involving Mr. Gatling and those defendants, and 3 defendants. They are reverses. They are reverses that took place in February 2013, okay? February, I believe the 7th, and February the 18th were the 2 where there was 2 kilograms of cocaine or 2 kilograms of heroin and 15 kilograms of cocaine on reverse that were orchestrated through agents from Memphis. Oh, this is what he was talking about. That was orchestrated from agents from Memphis that had nothing to do with our agents in Atlanta, okay? And the reverses, I believe them are reverse things. The evidence is overwhelming. There are phone contacts between the agents and the defendant and other defendants. There's surveillance. There's a car, a truck that's ultimately taken that was supposed to contain the 2 kilograms of heroin. There is a defendant, not the defendant, but other defendants showing up at the Butler Hill address, okay, where they were supposed to pick up 15 kilograms. Nothing in that, okay, has been diminished. No evidence regarding of the Franks hearing has had diminished or evidenced the strength of the government's case. I beg to differ with the respect to what she says about the Franks hearing. And obviously, you've got the memorandum, and they are what they are. So, expect for lengths of time involved, part of which I believe are responsibilities of the government because we were trying to get discovery to them, but part of which were caused by the delay by witnesses the defense called in that case. So I don't think any part of the due process issue, okay, has changed since your last ruling, with the exception of the length of the delay, the courts. Thank you, Mr. Hall. Anything further, Mr. Tarr, on behalf of Gatling? Ms. Tarr. Ms. Trawl. Just a brief reply, Your Honor. Response. Your Honor, I would question the government when Mr. Hogg had mentioned about the strength of the government's case, which includes 2 homicides. 2 people lost their lives. Mr. Such and Such was murdered on 2010 and Mr. Such and Such was murdered in 2013. We do not take these issues lightly. However, it must be presented to the court that based on the discovery provided by the government, Mr. Howard began cooperating with the government in July of 2004 and gave several proffers, which included testimony about 40 people or about 40 people in an ongoing drug conspiracy. And it also involved George Trevino, who was the head of the Mexican cartel. So to simply look that Mr. Gatling should be held responsible for such and such as homicide, there were a lot of other people who might have had a grudge against the witness, the cooperating witness. Mr. Gatling was never questioned by Metropolitan St. Louis Police Department about either murder, for example. That's a fact. And the reason that I talk about the proffer, and it was a very lengthy proffer back in July of 2004, it was made to a very, very well-respected detective, Detective Llewellyn, who was very, very specific. And in that proffer in 2004, it talked about all kinds of individuals, none of which was Mr. Gatling, which is Cuffy. It did involve Mr. Gatling's brother, Deron, but it had nothing to do with Mr. Gatling. And we believe there's enough individuals who had a grudge against Mr. Howard because Mr. Gatling didn't have any grudge against him. He may not have liked the fact that he spoke about his brother, but his brother passed in 2006 when he was in a correctional facility because of an asthma attack. So 4 years after, I don't think so, Your Honor. With regards to Mr. Morgan, who was derived from the Title III interceptions established in the case, which takes us back to the Franks hearing. So again, in Mr. Morgan's instance, he was never questioned by a city homicide. These homicides that I am aware of, these homicides never came into play until after the spring of 2015, when there was some difficulties with the government's case. With regards to the amount of time that had passed, Your Honor, and the government's part, we have never said it was Mr. Hogg's delay, or the United States Attorney's Office here. In case law, it doesn't separate government. There is no definition of government. The government is the United States, all the federal agencies underneath. So we're not putting an accusation or accusatory finger at the U.S. Attorney's Office, but the government as a whole has caused this delay. With regards to Tammy, CS1, and the continued intimidation, there was one fact that I would just like to bring to the court's attention. That it will recall there was testimony about her safety, her fear of safety, and one of the safety concerns was Mr. Gatling. Remember, Your Honor, it was Agent Cromer. Cromer's attitude about her, his control over her, that had nothing to do with Mr. Gatling. And as a result, she was kept in a Marriott for 2 or 3 weeks. So again, we have difficulties with that, Your Honor. Finally, with regard to the reverse stings, these reverse stings, I wrote articles about these reverse stings. Finally, with regard to the reverse stings, that's what they were. It wasn't, and we haven't even gotten to the pretrial motions regarding the actual matters relating to the reverse stings. But we must remember, Your Honor, that these came out of a phone conversation whose origin was in the affidavit, whose affidavit was predicated on Tammy, CS1. So we believe, Your Honor, that the difficulties with this whole case is predicated on an affidavit. If they wouldn't have had an affidavit, they wouldn't have gotten these phone calls. And if it falls, Your Honor, the whole case falls. That's why we believe that the strength of the case as we stand before you here on October 25th of 2017 has not the strength that it had back in March of 2014, March of 2015, or when the superseding indictment was filed in August of 2015. We therefore believe, Your Honor, that Mr. Gatling, that we have provided a scenario in which Mr. Gatling can be protected from himself and others by these measures, and we believe the government has borne its level of proof with regards to the danger to the community. Thank you. Certified. So, from the UK to DC, what's up? From our Cuffy was, Cuffy was. He had just got out of prison. He was trying hard. Oh man, Cuffy ass was thirsty. He was down bad trying to get anyone in front of him back. Lamar, why you so hard on, why you feel so strong about that? Wow, someone knows Tammy. 50 is playing poker and Tammy is the dealer, and they know. And they knew no one will look for the Suarez case or paperwork on the whole case now. Only Tammy's story will come out, and the BMF story is halted. Well, shout out to my inside man. They just sent me the Suarez case. I just went over that. You can go check out the last live. But as soon as I finish what I'm doing with this other jump, I'm gonna go do a breakdown on Fidel Suarez. Homeboy, serious business. Hold on one second. Yeah, I think I might do that right now before it get too late. Just about Suarez, who was later found not guilty. There's an order of acquittal. What you think about that, bruh? He was. I just know the backstory. This GBE Biz. Oh, that's GBE Biz. I be forgetting that Cuffy was too thirsty. I don't think he was too thirsty, bro. But I guess you could say that because he was going to meet all these different connects. But when you know how to jam, bruh, you know you need to connect to turn that faucet on. You know that, Lamar. GBE. So you said he came on the last time in 2004? All right, I got you. All right, well, I'm going to go read this other one. I'll be back, y'all.